What is arrest? In general terms, arrest means to take a person into custody because he has committed a crime, or because he is suspected to have committed some crime. The purpose of the arrest is to confine the body of the accused, so that he can be brought to justice if he is proven guilty by the court of law. Chapter 5 of the Criminal Procedure Code deals with the provisions of arrest of a person. These provisions run from Section 41 to Section 60A. Let's discuss these provisions. Who can arrest a person? Normally, we think that only a police officer can arrest. Of course, the police officer has the authority to arrest, but did you know, there can be persons other than a police officer who can make an arrest under Criminal Procedure Code? Let's see who all can make an arrest. First, police officer. Second, a private person. Third, a magistrate. We will discuss about the provisions relating to arrest by a police officer in a while. Let's first look at the provisions relating to arrest by a private person and arrest by a magistrate. Provision relating to arrest by a private person is covered under Section 43 of CRPC. A private person, just like you and me, can arrest a person or get such person arrested. There are two situations when a private person can make the arrest. First situation is where a person commits a cognizable and non-bailable offense in the presence of such private person. For example, if you see a person murdering another person, it will not be unlawful for you to arrest such person and get him into your custody. Second situation relates to proclaimed offender. If a person is declared as proclaimed offender by a court, then such proclaimed offender can be arrested by a private person also. Proclaimed offender is basically a person who is on the run even after issuing of arrest warrants against him, and the court declares him a proclaimed offender under Section 82 and 83 of CRPC. So, these are the two situations where a private person can arrest another person. Now, with the right to arrest a person, a private person is also bound by some duties after he has made an arrest. First, the private person is required to hand over the arrested person to a police officer, or in the absence of a police officer, take him to the nearest police station without unnecessary delay. After the arrested person is handed over to the police officer, or to the nearest police station, the police officer is required to see if such person can be arrested under Section 41 of the CRPC. If yes, the police officer shall re-arrest such person. If police officer finds that the person has committed a non-cognizable offense, and such person refuses to provide his name and address, then he will be dealt under Section 42 of the CRPC. If the police officer finds that the person arrested by a private person has not committed any offense, then such person shall be released at once. A very common example of arrest by a private person is theft. You must have seen, when a person is caught committing a theft, he is arrested by some people. Later, the police is informed and the person committing the theft is handed over to police. So, this procedure falls under Section 43 of the CRPC,